how do I change the parenting time that we have right now? The first question is there an order already in place that sets forth the parenting time that you have? That means you've already been to court, there's already been hearings, or there's already been an agreement on what the parenting time schedule should be with your child or your children. That's the order that needs to be followed until there is a modification of that parenting time. If there is an order that's already in place, you have to show that there's been a change in circumstances that rises to the level of requiring a change for your child or children. That doesn't mean that your work schedule changed or the other parent's work schedule changed, or you just think that they'd be more comfortable with you, or you think that it's just better overall for them to be with you. It has to be more than just your desire to have a change in the parenting time. Also, it has to be more than just a change in what the kids may want. Just because somebody wants something doesn't mean that that's a basis for changing an order of the court. What needs to be looked at is what are the exact circumstances that require that change. And it can be a whole slew of different factors. It can be that a school schedule change, that there's been a change in schools. Sometimes if a child reaches a certain age, maybe they've got a job, maybe one parent or the other has gotten married, maybe that one parent or the other has moved. There are certain changes that do happen in a child's life and surrounding that child's life that could lead to a modification of the parenting time plan. It's not just because one parent or the other wants it. There has to be that significant change with regard to that minor child. If you meet that threshold of showing that there's been a change in circumstances that warrants making a change in the parenting time, then what will happen is the court is going to look at the best interest factors for the child. It's very similar to making a custody determination, but it gets applied to the parenting time schedule that is in effect. It's really the same thing that'll happen even if there isn't an existing order. You're always looking at what's in the best interest of the children. If there is an order that is in place, you have to determine whether there has been a change in circumstances that rises to the level of the court reviewing the situation that you have. A lot of courts, quite frankly, will just kind of look at common sense, but there still has to be something for a change. I like to think that most parents will use their common sense in adjusting a parenting time schedule for the benefit of their children, but unfortunately, the other parent doesn't always act in the best interest of the children. If there is no order at all, and nobody's ever been to court with regard to the children, what needs to happen is a complaint for custody and parenting time needs to be filed with the court. At the same time, a motion for custody and parenting time needs to be filed. Typically, you're asking for specific parenting time based on the best interest of your child or your children. Then the court will look at that situation with fresh eyes and take a look at what is in the best interest of the child or children. One of the most important details that a court will look at when there is no prior order that's been in effect, they will look at what have those parents been doing prior to the time that that paperwork is filed with the court. What the pattern has been is going to be very important. Now, if one parent or the other is withholding the child or children from the other parent, that's a different ballgame. Just because one parent has had all the control in the past doesn't mean that they're going to hold on to that control moving forward. You have to make sure that you understand what has happened in the past and you take a look at what's in the best interest of the children right now and what is going to be in the best interest of those children moving forward. You want to make sure that you have a full awareness of the circumstances when there is no prior order that's in effect. The most important thing to do in both of those instances is to make sure that you have contact with and you hire an experienced attorney that understands the process, that understands what to look for, and understands how to educate you to put you in the best position possible for moving forward with either modifying an existing parenting time order or establishing an appropriate custody and parenting time order.